Wow, what a turnout. All right, let's see. Where do I begin? First of all, I want to wish everyone a good morning. Thank you, Justice, for honoring us with your presence. My name is Michael Zumo. I'm the president of the Long Island Lawyers chapter of the Federalist Society for Law and Public Policy Studies. Today's guest of honor's involvement with the Federalist Society goes back to its founding 30 years ago by a group of law students at Yale, Harvard, and the University of Chicago law schools, who challenged the then dominant liberal orthodoxy in the nation's law school. Justice Scalia, then a young law professor teaching at the University of Chicago, served as the first faculty advisor to its new Federalist Society chapter. Since then, both Justice Scalia and the Federalist Society have gone on to achieve great success. We all know that in 1986, Justice Scalia was nominated to serve as an Associate Justice on the United States Supreme Court by President Ronald Reagan. And the fledgling Federalist Society has expanded into every law school and court system in America, sparking a profound change in American jurisprudence. The Federalist Society was founded by a group of conservatives and libertarians interested in the current state of the legal order. The Society believes in the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is the duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further their application through its activities. The Federalist Society is a membership organization, non-political in nature, that seeks to advance our ideals by academic programs, debates, and legal writings. The Long Island chapter was founded in 1989 by some of the people in this room, including the aforementioned Grant Lally, Frank Chalace, Gregory Carmen of the United States Court of International Trade, and New York State Supreme Court Justices Bruce Cousins, who had to leave, and Justice Uta Wolf-Lally, as well as the late Justices Jack Dunn and Kenneth Malloy. Our guest today, Justice Antonin Scalia, was born in Trenton, New Jersey. As Monsignor Lasante pointed out, he's married to Maureen McCarthy and has 9 children.
Whoa.
And they've already been named, so I'm gonna forego that. He received his AB from Georgetown University with Justice Falanga as his classmate. And the University of Freiburg, Switzerland. And his LLB from Harvard Law School. And he was the Sheldon Fellow at Harvard University from 1960 to 1961. He was in private practice in Cleveland, Ohio from 1961 to 1967, a professor of law at the University of Virginia from 1967 to 1971, and a professor of law at the University of Chicago from 1977 to 1982, and a visiting professor of law at Georgetown University and Stanford University. He served the federal government as general counsel of the Office of Telecommunications Policy from 1971 to 1972, was chairman of the Administrative Conference of the United States from 1972 to 1974, and assistant attorney general for the Office of Legal Counsel from 1974 to 1977. He was appointed judge of the United States Court of Appeals for the District of Columbia in 1982. President Reagan nominated him as an Associate Justice of the Supreme Court, and he took his seat on September 26, 1986. In 2002, this is a little addendum here, he was awarded the Distinguished Service Medallion by the Nassau County Bar Association, the highest award which the Bar Association bestows. Please join me in welcoming Justice Antonin Scalia.
Thank you very much, Mr. Zumo. Monsignor Lasante, Reverend Clergy. Monsignor, I've been cursed a lot. I never have been prayed on. Members of the judiciary who are here and members of the bar. It's good to be back in Long Island. I miss it. I don't get back up here to New York or to Long Island in particular. very often. It's remarkable what has happened to the Federalist Society. I little imagined when we started a little student group in Chicago, simultaneously with the founding of a small student group at Yale, that it would grow to such a size and eventually have practicing lawyer chapters such as this one. It is not true, however, Mr. Zumo said that the society was founded in the day when there was a dominant liberal orthodoxy in the law schools. That hasn't changed. I had one of my law clerks who he joined the faculty at the University of Utah, and he was the only conservative on the faculty. So there's still a lot of work to do, and sometimes you get discouraged, but it's worth the fight, like Frodo in The Lord of the Rings, Soldier on is the name of the game. I'll tell you a couple of things this morning, and maybe we can have Q&A afterwards. One thing I tell to foreign visitors, but I think American lawyers and non-lawyers have to hear it as well. If you ask the average American, what is it that makes this the great free country that we've been for 2 centuries, the freest in the world, I mean, there's no doubt about that, they would likely respond, freedom of speech, freedom of the press, no unreasonable searches and seizures, freedom of religion, and so forth, the right to trial by jury, all the provisions of the Bill of Rights. And I'm glad we have a Bill of Rights. But if you think that that's what makes us different, what makes us freer, think again. Every tin-horn dictator in the world today has a Bill of Rights. Every banana republic, every president for life. It's the first thing you do when you take over a country. You promulgate a Bill of Rights, and the so-called world community applauds this wonderful liberal fellow. A Bill of Rights is cost-free when you have all the marbles. No, what makes us different is our Constitution. Think of the word Constitution. What is it? It doesn't mean a Bill of Rights. It means a structure. You say a person has a sound Constitution. That's what the framers debated about in Philadelphia. The whole summer, the middle of May to the middle of September. Just structure. How would we elect the senators? How would we elect the members of the House? What terms should they have? What power should the president have? What power should Congress have vis-a-vis the state? Those things. And with respect to that structure, we are very different from most of the world. There are very few countries that have a genuine bicameral legislature. England has a House of Lords, but all the House of Lords can do is make the Commons pass the bill a second time. That's all. Italy has a Senate, it's honorific. France has a Senate, it's honorific. Germany probably has a real separate Senate. But there are very few countries. And you know how hard it is, Representative King knows, how hard it is to get the same language through 2 different houses, which have different agendas, different leaders, sometimes even in the control of different parties. You got the same text through the 2. It's very hard. Most of the countries in the world don't have that problem. There are very few countries of the world in which the chief executive is not the creature of the legislature. All of the parliamentary countries, Italy, France, most of the countries of Europe, there's never any serious disagreement between the prime minister and the parliament. When there's a vote of no confidence, they kick him out. You have an election and the legislature picks a new prime minister. You realize how I go over to Europe sometimes to speak at a conference on separation of powers. You know what I end up talking about? Judicial independence, that's all. Because they make no effort to separate the two political powers, the legislative and the executive. And that's the hard part. Judicial independence is relatively easy, but separating out the two political powers, they don't even try. In Europe, you must be a member of the legislature in order to be the secretary of any of the divisions of the government. You can't be prime minister, you can't be the minister of the interior, you can't hold any of those posts unless you've been elected to parliament, which is why the party that's out of power always makes sure that their candidate is running in a safe seat. Because if he's not elected to parliament, he can't be the prime minister. He can't be any minister. Our system, just the opposite. Not only do you not have to be a member of the legislature, you can't be a member of the legislature if you want to serve in the executive branch. And I haven't even mentioned federalism. I mean, believe it or not, as big as the federal government has gotten, we are still very much a federal republic. I mean, you guys here in the state courts, you're taking care of most of the laws. You could just go down the list of laws. What? Contract law. Unless it's a contract with the federal government, the very few categories of contract that there is federal law about, securities contracts and so forth. But most of it is state law. How old do you have to be to contract? What constitutes a breach? What's the damages for a breach? The law of property, who owns real estate? Do you know what formalities are necessary to convey it? Who owns personal property? It's all state law. Criminal law, I mean, all the basic crimes. You can murder somebody in this country, and if you do it right, you haven't violated a federal law. You've committed murder. You haven't violated don't use a machine gun, and don't kill me. But if you're careful, you can kill somebody without violating a federal law. And all the basic laws that we're protected against. Burglary, robbery, rape, and so forth. They're state offenses. Different states have different requirements for the elements of the crime and different punishments. What else? Family law. There's no federal family law at all. It's all state law. The law of torts, unless it's one of the few torts that there's a Section 1983, unless it's one of those few private actions that have been created by the federal government, it's all state law. So we are overwhelmingly, if you, and I tell people when they come to the court, in one sense, this is the most important court in the country because we decide federal law, and federal law is supreme. A federal statute supersedes a state constitution. But if you, and that's why everything we say is of interest to the whole country. That's why we have a press gallery. It's always, for any significant case, it's full. Because everything we say is of interest for the whole country. But if you ask the average American, which court is the most important court to you and to your family, it's not my court. It's the state Supreme Court, which takes care of all of these other laws that I've been mentioning. I have to tell you, though, that although we are still very much a federal republic, we are now a federal republic by sufferance, because as a practical matter, once we adopted the 17th Amendment, whatever Congress wants to do, it can do. I mean, who do you think? I ask some law students, who do you think protects the states in our system? Now, yes, we have a federal government of enumerated powers. Who protects the states to be sure that the federal government does not go beyond its enumerated? They say, oh, the Supreme Court. What, are you crazy? I mean, I'm a Fed. I've been appointed by a federal president, confirmed by a federal Senate, and federal power is my power. I have no interest in restraining federal power. Over the long run, and now and then you'll get a quirky Supreme Court that may say, hey, a gun in the schoolyard is not interstate commerce, you know. Very. But that's rare, and you cannot count on that. No. The instrument, the founders were not fools. The instrument for the protection of the states was the fact that the states owned one of those two houses. They owned the Senate. In the days when the Senate was elected by the state governments, by the state legislature, not by the people of the state. And once you remove that element, you know, you could trace the decline of so-called states' rights. It happened in 1913, and from then on, you see the decline of so-called states' rights. So stop wringing your hands about it. It's been done. And the lesson is, don't tinker with the Constitution. You know, that amendment was adopted in a burst of populism, and then there was some corruption in the process. You know, the state senators would make deals with each other to appoint somebody to the thing. But, you know, there's worse things in the world than a decent amount of corruption. And I think if it was a choice between that and the elimination of the one protection for the states, I think we were better off with the old system. I think that's all that I really want to tell you about. The cases that I care about, I mean, I try to get all of them right. Even the statutory cases, the Bill of Rights cases, I'm glad we have the Bill of Rights. But the cases I really care about are the cases that affect structure, because that's what's brought us this far. And it is what preserves our freedoms. So you should think about that. And that's all that I have to say, and I'll be happy to take questions. You notice I don't say I will answer questions.
Josh, you have a question?
Yes.
I was interested to know what your opinion is on, I guess, the correct definition of rating, strict deference or sort of a partial.
Well, what the question is, what's my what's my view on judicial restraint and judicial activism? It reminds me of the first question I got when I was up for confirmation. Happily for me, the Senate was in Republican hands, and the chairman of the Judiciary Committee was Strom Thurmond. Okay. So I get up there, and the first question, he looks down at me, he says, "Well, Mr. Scalia, Judge Scalia, what do you think of judicial activism?" I said, "Let me have that one, Senator. I'm ready. Put it right over the plate there." But it is a conclusory term. I mean, it is not judicial activism, by my estimation, for judges to do actively what they're supposed to do. Which includes sometimes, because of the Bill of Rights or other provisions of the Constitution, telling the majority that the majority cannot do what it wants to do. That's what the Bill of Rights is all about. So when judges do that, they're being active, but they're actively doing what they ought to. So it's ultimately a conclusory term. When judges are doing what they shouldn't do, they're activists. And when they're doing only what they should, it's judicial restraint. But it doesn't really further analysis to use those terms. And some people criticized the Rehnquist court. Incidentally, I don't know why they call it the Rehnquist. Why blame Bill for I mean, you know, he has one vote like the rest of the judges. Our courts ought to be named after the last president to make appointments. So that, you know, we now have the Obama court, and before that it was the Bush II court. Because, you know, that really, why blame Rehnquist or Roberts or, you know, poor guy, he just has one vote. He can't make the rest of us vote this way or that way. Anyway, the Rehnquist court was criticized for being more activist than the Warren court. Why? Because it found unconstitutional more federal statutes than the Warren court did, which is absolutely true. But the conclusion that it was an activist court is absolutely false, because there is such a thing as an activist Congress that is enacting provisions such as, well, we never heard of before. I mean, you know, really weird provisions. And, you know, they run it up the flagpole, see if the Supreme Court will salute. That was sort of the attitude. And when you have a Congress that is sailing close to the wind that way, you should expect the court, if it's doing its job, to disallow more legislation than in other times. And of course, the Rehnquist court found unconstitutional many fewer state statutes than the Warren court did, which, you know, was whacking them down from one side to the other. So anyway, it's a conclusory term, and it doesn't help analysis. Yes, sir.
Good morning, Justice Scalia. Do you think that the Incorporation Doctrine is perhaps being overused?
Question is the Incorporation Doctrine being overused? Well, I don't know what you mean by overused. If you have the doctrine, the courts ought to apply it all the time, right? I mean, that's certainly not overuse. You guys know the Incorporation. Can you believe that was still controversial when I was in law school, whether the states were bound by the Bill of Rights? I mean, it was incredible. You know, the first state case we had involving the First Amendment was, or the religion clauses, I think in the 40s, in the 1940s. Nobody had thought the states were subject to the Bill of Rights. But, you know, the incorporation theory is that the 14th Amendment after the Civil War, when it guarantees equal protection of the laws, has the due process has the effect of applying the Bill of Rights to the states. I think that's probably not true, but we've been working that way for 50 years, and that's not one of the things I would not follow. I think stare decisis is, and it's no big deal. I just apply the same First Amendment rules to the states that I would apply to the federal government. I'm still acting like a judge. It's not like Roe versus Wade when I'm making up stuff. Yes.
Eminent domain.
Eminent domain.
Back in the day, eminent domain used to be a state or local entity seizing private property for the betterment of all. But with the recent Supreme Court decision, you have a private entity or a state or local body seizing private property for personal gain, that is to say, more tax revenue and the like.
Right.
Isn't it an inherent conflict of interest to give the seizing authority the direct benefit of that seizure?
Well, I mean, the question is about eminent domain in the Kylo case, saying that the Supreme Court has allowed states and municipalities, for that matter, to take away private property to give it to another private individual instead of using it for public purposes. And
Well, more correctly, the actual monetary
no, well, this way, it wasn't for monetary gain. Kylo, the theory was, of course, you know, it never came to fruition. The whole project fell on its face, so they took this old lady's home for nothing. But it was what they seized the property for in Kylo was to give it to this new industry that was going to pay a lot in taxes and going to employ a lot of people, and it was all pie in the sky. It never developed. But my court held 5-4 that that was a public use if you give it to another private company to do something that's going to protect or be beneficial to the community. I dissented in that case, and I think my court has, by my lights anyway, often been wrong about the law. But very rarely has it been wrong about how far it could push the envelope without really upsetting the people. It has very rarely been wrong about that. Dred Scott was one case. I think Roe versus Wade was another. I don't think my colleagues had any idea it was going to be that controversial, because in the circles that they traveled in, abortion was, yeah, it was okay. I think Kylo was one of those cases where they just misgauged the sentiment of the American people. There was a huge public outcry about that case. Many states have since adopted laws that prevent that kind of eminent domain, taking private property to give it to another private operation. So my guess is that Kylo is not long for this world. I think it'll be overruled eventually. Yes.
Ron Paul had said that when people object to the proposed bill to the Constitution, the general response from his fellow congressman is unconstitutional. Is that all you got? And the question is, does the legislature get an undue amount of deference, considering that's their attitude? The deference is due to the legislature's constitutional interpretation, considering
The question is about the deference that we give to the legislature when we rule on the constitutionality of statutes. And the questioner points out that many members of Congress don't consider the constitutionality at all. They just, as I say, run it up the flagpole. That's doubtless true, but I don't think that's any excuse for failing to give it deference. I don't give it deference because I think they considered the constitutionality carefully, or even because I think they would know what's unconstitutional if it bit them. I give it deference because they represent the people. It's really the principle of democracy more than anything else that requires you to approach that task with a certain degree of humility, of disallowing what the people want. So no, I think it deserves deference. Maybe it is true that in the old days they really thought carefully about. You used to have debates on the floor about the constitutionality of stuff. Can you imagine that? That doesn't happen anymore. Don't women ask any questions in this bar association? Yes, ma'am.
Justice Scalia, could you please give me your view on the role of Congress is supposed to have with the treaties? Because treaties have been signed without congressional consent, and also as far as the czars, the appointment of the czars.
I don't want to talk about the czars. That's one of the questions I'll take but not answer. As to treaties, the questioner wants to know what's the role of Congress with respect to treaties. She asserts that some treaties have been entered into without congressional consent. Well, it's just Senate consent, of course, but it's not true. No treaty has ever been concluded without the consent of the Senate, because that's what the Constitution requires. Now, there have been executive agreements concluded without the consent of the Senate, but they handle a much more limited scope of activity than treaties do. And of course, unlike treaties, they're not binding on the next president if he wants to kick them away. Whereas a treaty can only be kicked away by a repudiation by the legislature. The president cannot revoke our adherence to a treaty. So, you know, I think the system's working about the way it was intended. Yes, way in the back. The gentleman wants to know what's the difference between local commerce and interstate commerce. Well, I think we have essentially thrown up our hands on that subject, and what our current jurisprudence is, the gun in the schoolyard case, is that we will decide whether it's commerce. The court will. It has to be commerce that you're regulating. But once it's commerce, we're not going to parse whether it's interstate or local. That's up to Congress. Whatever they say, we'll accept. And we'll be lucky if that line holds. Yes, sir.
Justice Scalia, there are a lot of law students here today, all of whom admire you and love reading your dissents, and so...
That's who I write them for.
My question is, what is your advice to the next generation of lawyers and judges and members of the Federalist Society who attend law school? How do we do what you do?
What has happened to the law schools over the years is that they have removed themselves further and further from the bar. They were born from the bar. Harvard Law School was formed by the bar of Massachusetts. But over the years, they have grown closer and closer to the university, and more and more remote from the practicing bar, so that many academics have a positive contempt for the practice of law. You probably can't get a job on a law school faculty if you're more than 2 years out of law school and have been practicing law. They sort of, I'm dead honest about this. You know, I don't know, you've been making too much money or whatever. But whereas, even when I was teaching at Chicago, we used to value experience in the practice of law, and used to keep track of our alumni, but say, oh, no, she's not yet ready, leave her out in practice for, not approach her about coming into teaching. But that doesn't happen anymore. It's very hard to get onto a faculty if you've been in practice. That's very, very bad. But it must be part the responsibility of the bar. I mean, I don't think the bar pays any attention to what's going on in the law schools, to the fact that these professors who are training these people to be lawyers, for Pete's sake, that's what they get paid for. That's why these people are paying tuition. Almost all of them, except maybe at Yale. Maybe they want to be philosophers, but in most law schools, they want to be lawyers. And yet there's not the kind of association with the bar that there ought to be. I mean, everybody agrees. There was a wonderful piece by Harry Edwards 10 years or so ago. Law reviews are useless to the practitioner anymore. They used to be useful, but now there are these articles at the highest level of abstraction, just professors talking to each other. You can hardly even understand the darn thing. That's very bad, but part of the blame has to be with the bar. Do you keep track of your law school? Of whom they're hiring? Of what kind of courses they giving? It's literature on the law and all this garbage that you can take. You can get out of law school without learning any law. I, honest to goodness, had a law clerk once from I won't name the law school, a very prestigious law school, came into my chambers, said, can I borrow your Black's Law Dictionary? I was feeling cocky. I said, what do you want to know? I'll tell you. No, let me borrow it. No, I'll tell you. What do you want to know? I said, well, I've come across this word, subordination. Can you get through 3 years of law school without learning about what subordination is? It was a prominent law school, but you can do it. You can take these hobby courses that the professors teach. Now, do you pay attention to the school that you graduated from to see what they're teaching? To see who they're hiring? I bet you don't. So, you deserve what you get. But that's what's happening. The law schools are retreating from the bar. You ought to pay attention, and you ought to occasionally take a law professor to lunch or something. Yes, ma'am.
What accounts to that shift in the way they hire professors?
Well, once you reach a certain tipping point, law faculties are like amoebas. They reproduce themselves. And they hire people who are just like them. So once you reach a certain tilting point, they're going to. I don't know how we got there, but even when I was in law school, a fair number of the professors were practitioners. I mean, had an active practice besides. That's very rare now. And in the old days, wow, my colleagues at the University of Chicago told me, I couldn't believe it. Many law professors, indeed I, in my last years at the University of Chicago, I was making more money in consulting than I was from my teacher's salary. But in the old days, it was just like a law firm. Any money you made outside by publishing or anything else, you put it in the pot. It was divided among your partners on the faculty. Wow, what a different world. Yes, way in the back. I thought we fought a war about that. No, I think we did fight a war about it. Some countries have real difficulties in sorting out native rights. I mean, Australia does, and New Zealand does, and whatnot. We resolved those issues very facilely in a century that was in many ways more sensible. Now we do accord sovereignty to Indian tribes, a certain degree of it, but it's as much sovereignty as Congress wants to give them, because our opinions in the 19th century said that we acquired these lands, quote, by right of conquest. Whoa! Can you imagine any court saying something like that nowadays? Right. But it's the same thing about nullification, right of conquest. We fought a war, and those who believed in it lost. Simple as that. I mean, the Civil War was the great federalization of the country. I mean, the 14th Amendment in particular brought states much more under federal control than they had ever been. And that's what the war was about. Yes?
Morning, Your Honor. Could you speak to the notion that were the court to overturn the Health Care Act, that would be an unprecedented act by a group of unelected?
No. Yes, sir.
Thinking of the McDonald against Chicago case, can you think of any specific reason against
I don't know what case you're talking about. What case is it?
McDonald against Chicago?
Yeah.
Oh, okay. I'm terrible on case names.
Can you think of any specific reason against rehabilitating the privileges or immunities clause of the 14th Amendment?
The question is there any reason why we should, as he puts it, rehabilitate the Privileges and Immunities Clause of the 14th Amendment? I've never looked into the original meaning of the Privileges and Immunities. It's just never come up, and we resolved it categorically in a case that was decided not long after the Privileges and Immunities Clause was ratified. So I don't know what it was originally thought to mean. I do know that those who are finally abandoning substantive due process as the means of enabling courts to do whatever they want. I mean, it was the basis for Roe and the basis for a lot of stuff that courts have done. And of course, it's, you have to be insane to believe in substantive process. Close your eyes and imagine substantive process. It's the opposite of procedural substance. The world is divided into substance and procedure. To talk about substantive due process is ridiculous. So they're finally given up on that, and but many of them, like rats jumping off a sinking ship, want to jump onto the Privileges and Immunities Clause. And if we did rehabilitate that, it would end up being the same. What should I say? Handy tool for doing whatever you want that the Substantive Due Process Clause has been in the past. That's my fear. No, just one question. Yes, sir. Yes, sir.
Nothing quibble with you. Hasn't the 16th Amendment been more corrosive to federalism and undermines state plenary powers?
The 16th? Well, it's not just the 16th alone. It's the 16th combined with the interpretation of the taxing and spending power.
That's right.
But that's again stare decisis. That's a long time ago. But there are many who think that the provision that the federal government may tax and spend for the general welfare, that the phrase for the general welfare was meant as a limitation, that it could only spend for the enumerated purposes, okay? However, when it spent for the enumerated purposes, it had to be for the general welfare and not just for certain states. But it's too late. The court has interpreted that to mean they can spend for anything at all, even if it's beyond the enumerated powers. And so we now have, the framers would revolve in their graves that we have a whole department of education. What? Where? Article 1. Where is education in Article 1? We have a department of agriculture. Where is agriculture in Article 1? All that stuff has come in mostly through the tax and spending laws. Of course, they didn't have as much to spend before they had the income tax, but that's true. Yes, sir.
Justice Scalia, would you give us your interpretation of the Second Amendment specifically as it relates to personal protection versus that eternal check?
What's my interpretation of the Second Amendment as it applies to personal protection? Well, I think Heller makes clear that there is a right to keep and bear arms. It didn't say that you could only have arms in the home, but it also acknowledged that there could be state limitations on the keeping and bearing of arms, and that they could be used for personal protection, of course. But I'm not going to get into the details because we're going to have to sort out what those tolerable state limitations are, and it'll depend, as far as my vote goes, on what the traditional limitations accepted by the American people and understood by the American people at the time happen to be. You can't carry a bazooka around, even though it's portable, because there used to be a tort of affrighting. Affrighting was carrying around a terrible weapon, a terrifying kind of a weapon. I don't know, a head axe or something like that. So I'm for affrighting. Affrighting is bad. Yeah. Yes, way in the
No
back.
atom bombs on.
What do I think about the criticism that the Supreme Court acts in a political manner? Look, I used to speak about, the liberal and the conservative wing of the court. Until the recent departure of David Souter and John Paul Stevens, who certainly belonged to the so-called liberal wing of the court, they were Republican appointees. I mean, that's one of the realities that from the Warren Court on, the majority of the court has been Republican appointees. It's been Republican appointees who've been, doing all the stuff you don't like. Now, on the current court, I suppose by accident you might be able to say that the Republican appointees are all more conservative than the liberal appointees, but that's just an accident. And I assure you, the way they vote has nothing to do with their politics. I couldn't care less who the president is, nor do I think they could. Now, it does have a lot to do with their judicial philosophies. But of course, both parties have been selecting them on the basis of their judicial philosophies. Republicans have been looking for non-activists. Democrats have been looking for activists. So why should it be a surprise that in a particular case, the Democratic appointees tend to go one way and the Republican appointees tend to go another? It has nothing to do with politics. It has to do with who they are. And who they are had to do with why they were selected. So I have no tolerance at all for that political nonsense. The court is not a political court. And is it a court in which each individual has a certain philosophy of judging? Yes, it is. And to some extent, to a large extent, and to a greater and greater extent as the years have gone by, the political parties have been picking people because of that philosophy, which is bad. But it's inevitable once you have a court that is doing every doggone thing. I mean, once you have a court that is affecting the people's lives by inventing new rights, eliminating old rights all the time, the most important thing when you select a new justice is not, is this person a good lawyer? Does this person have a judicial demeanor? That's all very nice. But most important is, what kind of a new constitution will this guy write? Because we're revising it term by term. So the most important question when you select a justice, what kind of a new constitution will he or she write? Will he write the kind of constitution I like? Will it have in it, whatever you like or hate, gay rights, the right to suicide? That's the most important question. What kind of a new constitution will this person write? And that's why our selection it didn't used to be this way. It really didn't. My goodness, as recently as my confirmation, I was confirmed 98-0. And the two people absent were Barry Goldwater and Jake Garn. But it has changed enormously because it took the American people a while to figure it out. It's been going on ever since the Warren Court. But they have finally figured out that the court is revising the Constitution, the living Constitution. It is a living document. And we change it year by year. And once the people understood that, wow, it's a different ballgame when you select a new justice. It's a crazy system. It's like having a mini constitutional convention every time you select a new justice on the court. It's crazy. But that's where we are, and don't call the court a political court. It is not political. There are 9 of us, each of whom has his or her own view of the law, view of the Constitution. Now, the political parties selected them for those views, but that doesn't make them political. Yes. Young lady.
Hi, good morning. I was hoping to hear a little bit more about your views on privacy and law enforcement technology. And I'm sort of thinking specifically of Kylo and the thermal imaging there in the home versus sort of drones and the GPS tracking that went on there, and whether you think that the principal and the limiting factor there is really the issue of the home versus the car, which, as we know, is very different. And sort of if you think that there'll be any other structural, other types of limitations as law enforcement technology advances. And I thought of this, especially in light of the recent decision with the strip searches in the Florence case, and whether, how institutional reasons concerns balance against all these other privacy issues.
Well, it's a long question, and I doubt whether I can answer all of it, but it's about the Fourth Amendment. and the so-called right of privacy. My views are very, very easy to describe. I believe in the Fourth Amendment, which contains a certain aspect of privacy, but it is not a protection of any generalized right of privacy. And the Supreme Court used to understand that. The Fourth Amendment says that the people shall be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The strip searches that the young lady mentioned in the recent case, that's persons, so that's obviously covered by the 14th Amendment, and we had to wrestle with that problem. When is it reasonable, and when is it not reasonable? But for other so-called generalized right of privacy, I don't believe in it. It's not in the Constitution, and the Supreme Court did not used to believe in it. When we were first confronted with wiretapping, the Supreme Court, which used to understand the Constitution, said, is wiretapping persons, houses, papers, and effects? None of those. It's privacy, but it's none of those. And therefore, we said there's no constitutional right against wiretapping, which was correct. Many states had enacted laws against it, as there ought to be. But the Constitution simply didn't cover it. Some years later, in the famous Katz case, and later cases, the court overrules that and says it is covered, and the new test is not the text of the Fourth Amendment, but rather whether it is a right of privacy that society is prepared to recognize, whatever that means. Basically, it means whether we're prepared to recognize it, but that's the test now. Now, we had an interesting recent case involving the tracking device that was attached to the bottom of the car without a proper warrant. And the issue was whether that violated the Fourth Amendment. We held it that it did, but those who held it did sort of, I think, divided 5-4. I wrote the opinion for the court because I thought it violated, a car is an effect, it belongs to somebody, and you are trespassing upon that effect, which was a classic violation. Trespassing upon property to get information about criminal activity. That's what the Fourth Amendment was all about, so it was easy. The other 4 justices, however, and it didn't break out, the so-called conservatives versus so-called liberals, it didn't break out that way. The other 4 wanted to go with Katz, stay with Katz, and say that it was okay, it was a violation because there was no reasonable, that there was an expectation that when you're driving all around the place, nobody knows where your location is. I didn't understand why. The issue is whether Katz supplements the traditional Fourth Amendment or supplants it. And the 4 were saying it supplants it. So even though it didn't violate Katz, I would say, maybe it didn't violate cats, but it did violate trespassing upon your effects. Whereas they would say, oh no, it doesn't matter. In other words, not only have they gone beyond the Fourth Amendment, but they want to erase the Fourth Amendment that isn't covered by cats. I didn't understand that at all. Let's see where we are. Yes, way in the back. No, not you. You're not way in the back. She is way in the back. You get the question, when the court hears a patent case, yes, how do the justices educate themselves on the issue? The answer is very badly. We do our best, and I hope we get it right, but it's very hard. You know, the patent bar was all keen to have a specialized court. Oh, they were so delighted when they got the Federal Circuit to be, you know, the Supreme Patent Court. Now they hate it. They're grumbling about it all the time. And the disadvantage of having a court like that is, you know, for other courts, we can tell when there is a dispute about a particular issue. Because there's a circuit conflict. Some circuits come out this way, other circuits come out the other way. With patent law, it's all in the Federal Circuit. And you read the opinion and say, wow, that looks screwy to me. I have no idea whether it's screwy. You know, nobody else is saying it's screwy, except the lawyer, of course. It's his job to say it's screwy. But that's the disadvantage of having a specialized court. The Supreme Court does not have the signals of, yeah, this is a case you ought to take. But anyway, when we take it, it's I agree, it's very hard. Although, you know, most of the issues are not the technical issues that it's rather general principles. You know, what constitutes novelty, what requirements have to be complied with, and I think we can figure that out about as well as the Federal Circuit. Better than the Federal Circuit, my God.
St. John's, so maybe one more?
Yeah, a couple. Now, who did I not let ask a question before? That, yes, sir. I don't think so. Yeah. I just think it's too much water over the dam since then, and I think the American people, by and large, like having the agriculture department and the education department and all of that. I mean, this has not happened behind their backs, for Pete's sake. There are fewer people who think that our Commerce Clause jurisprudence is bad than there were who thought racial discrimination was bad. Okay? Yeah, I know. Well, they don't regard it as a danger. Of course, you know, the framers, I talked about structure, and one of the important structures of the Constitution was federalism. They were not willing to give this new central government all the power. And they said, you will increase liberty by dividing power this way between the federal government and the states. And the more you give to the federal government, it becomes Leviathan. But the people apparently like it, and we have court decisions that are stare decisis that adopt it. And I think if you put it to a public vote, I'm afraid you're in the minority, probably the vast minority. Yes, sir. Yeah. So what?
And Kagan has to get the coffee. We get
Oh,
it.
it used to be
That's how it
a
works.
lot better for John Paul Stevens, because when the chief is in dissent, it's the senior associate justice who either writes or assigns the opinion. And when you disagree with the chief a lot, that's a good post to have. And John Paul Stevens loved it. I don't disagree with the chief that much, unfortunately. Maybe I'll have to learn to do that. But other than that, I think he does try to give the senior. For Pete's sake, something ought to come with the title Senior Associate Judge. I feel like I ought to come up here with a walker, a Senior Associate Judge. Yes, sir.
A lot of the ballot access cases have talked about casting, the right to cast an effective ballot or a meaningful ballot. How can the citizens have a right to cast an effective ballot when there is no corresponding right to be a candidate?
I don't see the connection. You want to be able to vote for anybody? Anybody ought to be able to write in anybody's name when is that what it takes to make an effective ballot? We have a process for selecting candidates, and you got to follow that process. And among the candidates selected now we have overseen the state's process of favoring candidates and eliminating candidates, and we have certain limits on that. But you got to go through that process. Otherwise it's chaotic. It's chaotic otherwise. You can't have town meetings. Yes, ma'am. You.
Over the past number of months, maybe a couple of years, some of your fellow justices in public statements have referred to considering international law when deciding cases. Without, I know you're not going to tell me which country we all know, but I mean, it's the,
I know who they are.
should that even be considered when we're dealing with our laws and our constitution?
You're preaching to the choir here. No, I don't think international law has anything to do. Well, sometimes I will consult international law. I will consult international law when we have adhered to a treaty. Okay, I will do that. I will even consult international law concerning the meaning of that treaty. If the object is to have all the signatories on the same page, and if 3 other countries have already interpreted it a certain way, I'm inclined to come out the same way if it's ballpark, okay? But other than that, and where they usually use it, is in the interpretation of our Constitution. What privacy rights there ought to be, okay? I cannot for the life of me understand why what the French think should have anything to do with the meaning of our Constitution. And the French are the best. I mean, the international community is even worse. You wouldn't want to live in most of the countries of the international community. And I should accept their notion of what is good and just and moral? The heck with that. Yes, in the back. Yes, sir. How do I balance the constitutional protections for United States citizens and the government security interests? And again, the answer is very carefully. There are certain absolutes. There are just certain absolutes, and you simply cannot transgress those absolutes. It's funny, many people are willing to let Congress transgress absolutes. Oh, it's just absolutely necessary. Oh, well, then it's okay. You wouldn't think of doing that for the president. There's no other way to get these criminals except unauthorized wiretapping or, rubber hosing them or whatever. Well, if it's the only way to do it, you got to do it. No, we don't accept that for executive action, and we shouldn't accept it for legislative action either. There are some absolutes. Now, the absolutes do not include the Fourth Amendment, which is not phrased as an absolute. It prohibits unreasonable searches and seizures. So there is a balancing between what is necessary to secure the country and what the Fourth Amendment protects. Now, in the days when I was head of the Office of Legal Counsel, it was before the Foreign Intelligence Surveillance Act had ever been enacted. The Attorney General, on his own, used to authorize what the FBI called in those days black bag jobs, which were physical intrusions into often the home, the residence, or the hotel room of people suspected of being foreign agents. It was only for foreign intelligence purposes. But if you had Colonel Abel staying at the Ritz in New York and you want to get his code book, you can't get a warrant because he hasn't committed any crime. You just know that he's an intelligence operative and he has a code book. And if you got a warrant, you'd have to serve it on him, whereupon they changed the code. So what you want to do is sneak in, photocopy the code book and get out, and he never knows about it. And these used to be authorized by the Attorney General on his own. And then suddenly they brought intelligence in from the cold. It used to be, gentlemen, don't talk about that stuff. And Ed Levy was sued for permitting some, and Ed Levy had money. I mean, he was worth suing. And worried about defending. But that's what the Fourth Amendment means and what it allows. Now, that's since been turned over to the Foreign Intelligence Surveillance Court. They approve these kinds of actions, but it's only for the collection of foreign intelligence. So, there are a lot of other instances where you have to reconcile what is reasonable under the Fourth Amendment with the needs of national security. I don't think it ever includes, killing people for no reason. Anyway, yes? Can't hear you. You mistook me. I don't care what the American people want when I make constitutional decisions. I do take into account stare decisis, and one of the things, and that's a what do you say, a policy call, a discretionary. When do you give dispositive effect to precedent, and when don't you? That's very much a judgment call. And one of the things that goes into my judgment is, if I were to overrule it, would the American people put it right back where it was before? And I think on most the kind of issues you're talking about, I think they would. If necessary, by amending the Constitution, or if not that, by getting their representatives in the Senate and the President to either to expand the number of justices on the court and put in people who have the old-fashioned view of the Commerce Clause. I mean, does none of that scare you? It ought to. That's something you have to take into account when you decide whether to depart from prior cases. Now, two more questions, and then I got to get out of here. Yes, sir.
I just want to know what your take was on the Trayvon Martin case, and also, do you think that what the case about that was placed out for arrest and Viking's speech on Twitter, does that protect the speech under the First Amendment, or do you think that's outside the scope of protection?
Oh, I don't want to get in. I don't want to get into that. No. It'll be in the paper tomorrow.
Good, let's get your hand up.
Yes, sir.
Mr. Scalia, under what circumstances, if any, do you think legislative intent or legislative history is relevant in deciding your cases?
That's a bad last question, because I could go on for half an hour on the question is about legislative history. When do I think it's appropriate? I never think it's appropriate for two simple reasons. The first and most basic reason is that we are not governed by legislative intent. We are governed by laws. That's what it means to be a government of laws, not of men. What does the law say? What does the law convey? I don't care what the people who voted for that law had in mind. If they didn't say it, that's their problem. We're governed by laws. And the notion that somehow I should go behind it to see really what they had in mind is contrary to a government of laws. That's the first reason. The second reason is, even if you thought that it was relevant, what they intended, what makes you think you're going to find it in legislative history? For most of the questions, almost all of the questions we decide, there was no legislative intent. It's subsection 322B1 little c, you know. They weren't thinking of that. You're lucky if they just are coming into the chamber. You vote aye, you know, the whip tells vote aye, vote nay. You're lucky if they know what the title of the statute is. Like section 322B little, come on. There is no legislative intent. Almost always there isn't. So you pluck out, you know, a statement by the guy who wrote the bill or by the committee report, but they don't vote on the committee reports. They don't even read the committee. Even the committee doesn't read the committee reports. It's not even written by the committee members. Staff puts it together. And to somehow oh yes, we have found the legislative intent because this teenager put in this provision. I mean, it is the last surviving fiction in the common law. It is an absolute fiction, so I don't use it. I have very much enjoyed being with you.